Am I visible and audible?
Yes.
Okay, thank you. Thank you.
Yes.
Thanks. Okay, so task 2 is your drafting of an anticipatory bill. So, first of all, to um, just to give you an overview, bail is a legal process which allows a person who has been arrested or detained by the police or other law enforcement authorities to be released from custody temporarily under certain conditions. So this particular instance happens only when the trial is still ongoing or the trial is still pending before the court. Um, Now, this bail, it serves as a mechanism to protect the rights and liberties of individual, in ensuring that they're not held in detention for a long period of time. Now, since it is a common principle that is followed in India, where you know the uh, you need to be produced before a judicial authority before um, so before you actually within 24 hours, basically, you need to be produced before a judicial magistrate, wherein he can either grant you a bail or start a case against you. So basically, what it means is that it like criminals or accused people are not supposed to be held in uh, detention or in custody for over 24 hours. So yeah, so the concept of bail, as we all know, is governed under CRPC. People who have not read CRPC, this is specifically for y'all. So there are certain points which are taken into consideration while you're even studying about bail or you're reading about bail or you're drafting a bail petition, etc. Number one is it is a temporary release. If you are issued a non-bailable warrant, which is the court's order to, to the police authorities to arrest you, you cannot have a bail. Second is presumption of innocence. India follows a principle where accused is innocent until proven guilty. So that presumption or that concept is also followed in the bail, like in the concept of bail or while drafting a bail or while reading about bail. There are two kinds of offenses. Okay, so if people who studied CRPC know about it, there are three categories of offenses. One is bailable, non-bailable. Another one is compoundable, non-compoundable. And the third one is, if I'm not wrong, just a minute.
Commutable and non-commutable.
Thanks, Asta. Thank you. um, okay, so there's non-cognizable, non-cognizable, bailable, non-bailable, and there's compoundable and non-compoundable. These are the different kinds of offenses. If you want to read about it, please do your own research. But bail is issued only for bailable offenses, where you can get a bail. Non-bailable offenses are such offenses where you can't get a bail. Uh, Generally, right now, anticipatory bail is a completely different ballgame. Now, there are certain conditions which need to be followed before granting a bail, number one, drafting a bail, number two, reading about a bail, number three. Now, anticipatory bail is your task or is your topic for discussion. Anticipatory bail is it's like a backup that you have. You think you're going to get arrested, so you give an anticipatory bail application to the court. The court accepts it, and if anytime a police authority or any person who is allowed to arrest you comes over, tries to arrest you, you can show them the bail, and if they still forcefully arrest you and take you, they are liable to be punished under the Criminal Procedure Code itself. Now, there is judicial discretion while granting a bail. There's cancellation of bail on certain grounds, which I will be talking about in the future slides. There's appeal and revision. For example, you're not happy, and bails are usually applied only from the Sessions Court upwards. Or if I'm not wrong, it's from the Sessions Court, or it might be from the High Courts as well. Just 1 minute. Sorry, guys, just give me 1 second. I'm getting a call. Sorry for that. Anyways, so bail is usually granted appeal and revision, right? So bails are usually, so you start off with an application to the Sessions Court, unless it's a high profile case or it's public authorities or government involved. You usually apply to the Sessions Court or to the court which is just below the High Court in terms of the criminal courts, right? So basically, in summary, the bail in India is a legal mechanism that ensures the accused rights to liberty and fair trial while also considering interest of justice, right? So moving on. Um, there are several types of bails in connection to the individuals who've been arrested or detained in connection with a criminal case. Now, the type of bail granted, guys, please mute yourselves. Okay, so the type of bail granted depends on the nature of the offense, first one, discretion of the court, number two, and specific circumstances of the case, number three. So therefore, the bails are classified into 7 types. First of all, regular bail. Regular bail is usually granted in bailable offenses, and it's a matter of right for offenses that are classified as bailable. Now, in the Criminal Procedure Code itself, there are certain offenses which are classified as bailable offenses, and there are certain offenses which are classified as non-bailable offenses. Regular bail is granted for a bailable offense as well as a non-bailable offense, but first we'll be looking at the regular bail granted as a bailable offense. Now,
Excuse me, Raksha.
yeah,
I have one query. Can I ask
yeah,
regarding
sure.
can we have some sections which are available? Will you
Sections
elaborate
which
on
are
it?
available, right? Okay, like I'm coming to that. Just give me 2 minutes. Okay,
Okay.
okay, yeah. So bailable offenses, the regular bail granted for bailable offenses is again on the discretion of the court. Um, just 1 minute, please. Okay, so it is on the discretion of the court, and okay. It is on the discretion of the court, and the accused must provide a personal bond to the court before and as well as sureties before he takes the regular bail for a bailable offense. Now, common examples of bailable offenses include minor traffic violations and some minor criminal offenses, like for example, um, your negotiable instruments where your check is for like maybe 1,000 rupees and um, you don't it is not as an offense of a very serious nature, so you don't really need to like it is not super serious, right? So the court can grant a bail as and when it thinks fit. Now your regular bail for non-bailable offenses are uh, the accused does not have an automatic right to bail. Now in such cases the accused can apply for a regular bail to the court which has jurisdiction in that particular area. Now, again, it is granted on the discretion of the court. The evidence is produced by the accused, as well as certain conditions and terms that the courts impose before granting the particular bail in a non-bailable offense. Now, certain kinds of non-bailable offense include dowry death, number one, murder, rape, all of those. Uh, if the accused is able to prove himself beyond reasonable doubt that, okay, he's not done anything and the court is convinced, that is when the court can grant a regular bail for a bailable offense. That is a bailable offense. Certain offenses which cannot be forgiven or which you can't take a bail for. Again, bails are given. There are a lot of cases where bails are given even for non-bailable offenses, but that again depends on the discretion of the sessions judge or the high court wherever you're applying. Moving on to the anticipatory bail. Anticipatory bail is a type of pre-arrest bail. Like I already mentioned, you think you're going to be arrested, so you already apply to the court um, for a non-bailable offense. Okay, so that you need to keep in mind. It is for a non-bailable offense. For example, you might not have done anything, right? You might not. Okay, I might not have murdered someone, but I think uh, so. But I think that I might be caught for murdering someone, or I might be arrested for murdering someone. So giving specific reasons, alibis, evidences, everything you apply to the authority for a bail. These include dowry harassment, outraging the modesty of a woman, which is your task. Um, then you have the court may grant anticipatory bail with or without conditions to ensure cooperation with investigation. So the court needs to make sure that investigation is cooperated. Like, as in if I'm the authority or I'm the police and I'm conducting investigation, nothing should come in between me and the investigation. So if the accused or if the person who is arrested, who might get arrested, if he's not arrested, he might be a hindrance to the whole investigation. So the opposite party is the state for non-bailable offenses. Usually, opposite party are usually the state. So if you ever see any, if you ever have the chance to go through any rape cases or the judgments given or anything like that, you will always see that it is with the state, because in criminal cases, there are no two parties involved. It is usually the state which takes the first head, and then the party comes as defendant two or defendant three, depending on their offense, right? So then you have interim bail. It is granted by the court when regular bail is not available, right? It is in exceptional circumstances and it is subject to conditions. Interim bail is not very, very, very common, but it is still in existence, and it still is something that you need to know that it is a kind of bail. And the next is default bail. It is granted when the accused is not tried within a stipulated period as specified in 167 clause 2 of the CRPC. So the police fails to file charge sheet within the prescribed time frame. Thank you. So the accused become entitled to default bail when there's a fault on behalf of the state, as in the state has taken a long time, or maybe 3 months, 90 days have already passed, and then they've started the investigation. That's where the accused can apply for a default bail. So he'll get it regardless, because he will specify certain conditions or certain reasons why he thinks that this whole procedure is rigged, or the entire system is rigged. And if the court accepts it, default bail is granted. Now, admission to bail, this is usually in case of juveniles. If you don't know, we have a separate act for juveniles. It's called the Juvenile Justice Act, wherein people who are below the age of 18 are tried under the Juvenile Justice Act, and they are given certain leeways or certain things that they don't need to follow procedures. Or there's something called Children's Court, which has come into existence. There's something called the Child Welfare Office. All of those, once they get involved, that is when bail. So usually juveniles, unless they are from the age bracket after 14 to 18, they're not even kept in custody for even an hour. It is apparently a violation of human rights. I have different opinions on it, but that's not something I'd like to discuss here. Now, special bail under specific laws. Now, these are certain laws, for example, the Money Laundering Act, the Narcotic Substances and Psychotropic Abuses, like that act. There are certain other acts like prevention of the Prevention of Detention Act. There are some other similar acts where specific bail, it is mentioned under those provisions itself, and the bail is granted accordingly. Just give me a second, please. All right. Okay. So in conclusion, it is not important. It is not an absolute right of the individual A bail is not an absolute right for an individual, especially if non-bailable offenses are involved. Now, the court considers a lot of factors like nature of the offense, seriousness of the offense, strength of the evidence, the accused's criminal history, the likelihood of accused interfering. All of these are basically reasons which the court takes into consideration before granting in any kind of a bail. Okay, moving on. This is so section 438 basically talks about what an anticipatory bail is. And in accordance with section 438, a person who anticipates being arrested may be granted anticipatory bail for non-bailable offenses prior to FIR being filed. Once an FIR is filed, you cannot apply for an anticipatory bail. So this is before anything, before even the information has gone to the police that, so here's the catch. Once a complaint is filed, you can still apply for anticipatory bail. But if the formal FIR is lodged, you cannot file. You cannot file for anticipatory bail. But when an individual is arrested, they must apply for regular bail or interim, depending on the situation of the case. Now, an anticipatory bail is the direction to release a person before bail, on bail, even before the arrest. Like I've been mentioning, this is a pre-arrest bail. So you think you might get arrested. So before that happens, to protect your interests, because you might not have done anything, so you just apply for an anticipatory bail, and the court more often than not grants it if you have proper conditions and you have proper, reasons and evidence and alibis to support your claim. Now, these are conditions for granting anticipatory bail in India. Again, there is the reasonable apprehension of interest. You think you have a genuine and reasonable belief that they might get arrested. Okay, that is the first condition. Condition number 2, nature and gravity of offenses. The court considers the nature and seriousness of offense for which anticipatory bail is sought. In some cases, such as heinous crimes, the court may be less inclined to grant anticipatory bail. Again, if you're smart enough, you will be able to get the court to believe you, or you will be able to get the court to convince the court to basically grant you an anticipatory bail. This is again all on the kind of advocate you choose or the kind of reasoning that you have before you apply for the bail. Now, cooperation with the investigation. The accused must, in written, signed, verified by witnesses, must need to submit a affidavit or not an affidavit. It's like a kind of letter thing, but it's like super small. So it's like the name of the court and the case name and the party's name and the short title is what we call it. And then you have your reasoning. Okay, like, oh, I am this and this and this. I am the accused in this and this and this. Criminal number, file number, case number, depending on your jurisdiction court. They have certain different ways that they number files. And then you write this and this and this and this are my reasons. I swear on oath in this affidavit that I will not be interfering with any investigation. Again, so no misuse of the anticipatory bail and no interference with any investigation. No flight risk. So that is something very important. The accused is not permitted to leave the jurisdiction of the court or the jurisdiction of that particular police station unless they take permission first. So this is something which is a little iffy for most people, but it is just so that we don't have another Vijay Mallya, right? We don't have another people, like we don't have people who've actually left and they've done certain offenses and they've left without the court even having jurisdiction in the first place to get them back. Then you have record and character of the appellant. Now the criminal record is basically checked, and a clean record and good character can work in favor of granting an anticipatory bail. Guys, I have 7 seconds left. Please join back. Just give me 10 minutes. The video will purge, and then I will share another link or the same link. I will let you know. Okay. Thank you.